Yes.
May it please, Your Lordship. Lordship, this is regarding that item 9 of part 2.
9.
Yes, Your Lordship. That RFA. Your Lordship, there is one connected case, one RSA 3 of 2023. I've provided the last court order. This is 5th of July 24, wherein there was a
Let's see the
direction.
5, item 9. So both the matters are not listed together.
They're not listed together, but in fact, in law, they're both the same because it relates to one and the same family agreement. It's just that the parties are different, but it relates to the same document in question. Paper book is already received by all the parties concerned, and we've inquired with the registry, and it can be listed for hearing. This RSA.
So if it's listed for hearing, won't it be appropriate if both the matters are
If it's listed together,
Maybe it would be appropriate, I think, my lord.
more appropriate?
Yes,
isn't it?
without tagging together, but it may be listed together so that the main issue will be pertaining to the family agreement.
Parties are different.
parties
Yes.
are different, but same agreement. Basically, Your Lordship, what happened is that, as we call it in Mizo, we're all brothers and sisters, and we're living in that what we call a Mizo family colony, as to say. So previously, it was covered by one LSC. So that's where all the confusions started.
So the parties in the RSA,
My lord,
are they related to the parties in the RFA?
they are all related. They're all relatives.
But the property is different.
Property is the same, also the same. Just that the parties are different.
The main issue will be, my lord, whether family agreement will be binding upon the family
In
members.
the RSA, it is concerning the family agreement.
Agreement is
In the
exact.
RFA also, it's
Also,
the family
right.
agreement.
Same agreement.
agreement.
Although the matter is bit different, but
How is it the matter different? How is the
different
matter
in the sense that, your lordship, in the present RFA, it is the parties are different with the RSA, but the basis will be the family agreement only, whether it could be binding upon the all the parties.
Just to add to my learned friends,
Okay, wait. So the appellant in the RFA and the appellant in the RSA, they are different. But they are saying that the family agreement is binding or what?
so that's exactly, Your Lordship. In the RFA, the contention is that my rights should be governed by the family agreement, according to them. And in the RSA, we are questioning the family agreement itself. Because what happened was that the
And you are
family...
the appellant in the RSA.
Yes, Your Lordship. What happened was that the family agreement was indeed executed between the parties. Now, thereafter, during the life, the property in question was registered in the name of our grandmother. And she was also signatory to the family agreement. So subsequently, during her lifetime, she acted against the family agreement. So the question now is whether a family agreement, one of the substantial question of law involved in this RSA is whether a family agreement can be equated with a will as far as the law is concerned.
So now the grandmother has passed away.
Passed away now. But during her lifetime, she had acted against the family agreement. So that legal issue will have to be adjudicated. If that is decided this way or that way, the RFA will automatically be covered, in my humble opinion.
It's okay, but I'm just trying to figure out why are the parties different.
No, different uncles. Our grandmother had there were as many as 5 brothers and sisters. So siblings from different uncles and aunties.
In the RSA, when they're saying that the agreement is not valid or the agreement is valid, the other side, the other party, why weren't they all made a party at one time?
Because there were 2 different cases had been filed. It is arising out of 2 different civil suits.
See, because one will say the family agreement is binding. the other will say it's not binding.
Right.
So those who are saying that the agreement is not binding, why weren't they all clubbed together in one case?
I think
Your Lordship,
Yes,
Please go ahead.
in the RSA matter, the issue involved is that the present appellant had extended 12 feet of the land towards our land. So that was challenged because it had already been settled in the family agreement. That is the issue. And in the RFA issue is that the present appellant's, that the LSC was mutated in favor of the present appellant. That what we challenge in the trial court, saying that as per the agreement, family agreement, it could not be mutated in their favor because it has to be our share, as
Okay,
already
and in the
decided in
other
the
it
family.
was already this thing.
Yes, so basically the family agreement will be what have to be looked into.
yes.
That is the basic.
both-
So,
both
yes,
In both the cases,
in
what
order
happened-
to
Anyways,
adjudicate both the cases.
it's the same LSC, but it refers to a different location of the LSC.
And they cannot come to any settlement. Have they made an attempt? How many times have they sat together?
I think we are both at least I did not represent them in the previous round of cases, so I don't know about that.
Have you made an attempt to come to some settlement?
think not.
All family members?
Maybe not yet, Manu.
Maybe not yet.
Yeah, because CPC
purely-
also provides, isn't it, with section
100. Oh,
yes,
sorry,
that,
89.
89 maybe, that attempts should be made to come to a
Yes.
settlement through any alternative dispute this thing mechanism, isn't it? So
The issue is very small. There could be.
then we'll refer this case, if RFA is referred, automatically RSA can also be settled? If RFA is settled?
I-
Or both of them?
Both it would be
Because
better.
the parties are different.
Parties are different because within the said land, their interests are not the same.
Yes,
So
if
I
it has to
think
be.
both RSA
cases.
and RFA, both of them have to be referred.
Yes,
So you get the consent
my lord.
from the parties first if they're willing to come. Learned Counsel for their respondents. The Learned Counsel submit that this matter needs to be listed along with RSA number 3/2023, wherein in both the cases a family agreement said to be executed between the parties are involved, even though the parties are different in the present RFA 25, in the present RFA and the RSA number 3/2023, the issue evolves around the same family agreement. On hearing the submissions made by the learned counsels for both the parties, it appears that since the dispute is between, is it siblings
No, family members.
or the family members, this court find it appropriate that the parties should make an attempt to come to an amicable settlement before proceeding further. In view of the above, the learned counsels for both the parties are to get instructions whether the parties are willing to have the matters, that is RFA number 25 of 2023 and RSA number 3/2023 referred. You want it Lok Adalat or mediation? Same.
Mediation.
Mediation would be better. ma'am.
Referred to mediation. Yes. List the matter. When do you want it?
After a week, ma'am.
In the next week.
In the next week.
Much obliged.
Much obliged.
Oh, may I seek your lordship indulgence in making a mention with respect to part 2, item number 6, my lord. Yes, my lord, this matter is was fixed for hearing today, but due to personal difficulties, the leading counsel Joseph Lelsan Hima Rentley could not appear, my lord.
What happened?
My lord, they were recently blessed with a baby, my lord.
Oh, so he has taken paternity leave. Is it? Okay. We are the petitioners, isn't it? So we
I
are
am
the
the
ones who should
petitioner.
be pressing the matter. Yes, mention is made on behalf of Mr. Joseph Lalsan Himarentle, learned counsel for the petitioner for adjournment of the matter, which is not objected by Mr.
Arlal Hunsiama.
Arlal Hunsiama, learned standing counsel for respondents number 1 to 5. In view of the above, list the matter after
2 weeks, my lord.
2 weeks.
Yes, my lord.
2 weeks.
Obliged.
Obliged.
Daily list for motion, item 1.
Lordship, this pertains to that suspension of football players for lifetime, 5 years. And in Lordship, as you are aware that you passed an order on 19/6. The order is at page number 12. And so you give direction. Operating part, may I kindly go quickly to page number
Yes.
14,
Yes.
para 6. You're there, Lordship? Can I read?
Yes.
Accordingly, this court finds it appropriate to dispose of this writ petition at motion stage without going into the merits of the matter by directing appellate authority Mizoram Football Association to dispose of the appeal. I want to stress to dispose of. So this is to dispose of the appeal filed by the petitioners on 13/11/2024 expeditiously, preferably within 2 weeks from the date of receiving a certified copy of this order, by taking into consideration the urgency expressed by the counsels for the petitioners. Appellate authority shall consider the said appeal in terms of AIFF Code 2024, ensuring that principles of equity and fairness is duly upheld. And after passing of this order, we applied for certified copy, and on 24/6, the next page on 15, we had furnished this judgment and order on 24/6, which was duly received by the office, by the contender, on 25th, the next day. And my lord, so, and we had also filed,
Not this thing considered till
not
date,
yet
is it?
considered, and besides that, I had filed a letter on 22nd also to represent them as per AIFF code, and after that also on 17 July at page number 24, I requested to dispose of the appeal. To dispose, because the language is to dispose of the appeal. So on 17 July, so this is the reason I have come before this honorable court.
Okay, so no steps taken till date, huh?
My lord, yes.
Yes, what is going on?
My lord,
Will issue notice,
yes,
but
my
you're
lord, after
representing?
that, after issuing notice, they can say what they want to say.
My lord, I have instructions to appear on behalf of the Secretary MFA and the Secretary Disciplinary Committee. That it is true, my lord, that this honorable court has given directions to dispose of the matter preferably within 2 weeks. That, my lord, that was taken into account, and the learned counsel for the petitioners were sent a notice to pay for the appeal fee, as per which is mandated by the AIFF code.
Okay, you file your this thing, you file your reply,
Yes,
your cause reply, and then let's see what you have to say concerning that, isn't it? Then dispose it of, whatever is required, you do it. Yes, heard Mrs. J.C. Lunsanga, learned counsel for the petitioner, who has filed the instant application under section 12 of the Contempt of Courts Act, 1971, read with Article 215 of the Constitution of India, for initiating a contempt proceeding against the respondent/contemptor on the grounds that, in spite of this court's order dated 19/06/2025 in WPC number 58/2025, directing the respondents to dispose of the representation filed by the petitioners not representation, appeal, okay, to dispose of the appeal filed by the petitioners on 13/11/2024. Expeditiously within a period of 2 weeks from the date of receiving the certified copy of the said order, comma, the respondents have failed to dispose of the appeal, even though copy of certified copy of the order was received by the respondents on 25/06/2025. Issue notice to the respondents. Ms. Raisake Nifanai accepts notice on behalf of respondents number.
Respondent only one.
Okay, on behalf of the respondents, requisite copy of the petition to be duly furnished to the learned counsel. List the matter after 2 weeks.
It's fine, Your Lordship.
Oh, 1 week. You seem to have your answer already, so we'll
Yes,
make
my
it
lord.
1 week.
The thing is that, my lord, notice is not
No need to issue formal notice. The learned counsel for the respondents is to file their show cause notice, show cause reply, okay, not notice, show cause reply within a period of 1 week. In the meantime, this will not bar the parties to take necessary steps for compliance with this court's judgment and order. Yes.
My
Your
lord,
Lordship, they can either reject or dismiss my appeal in the meantime also.
necessary
Whatever they
steps
say,
can
let
be
them say.
taken, yes.
my
Yes.
lord, if I just make one submission, the only problem we're facing here right now is they are not willing to pay the appeal fee, which is an amount of 60,000. Appeal committee is already set up, and then those who have paid the fees, the appeal fees, their appeal is going to be heard in very
So
soon.
dispose it of.
That's
Yes, my
why
lord.
they can dismiss also.
You can say, since appeal is not, fee is not paid, we are not going to consider. Close it. If
That
you
is
want,
what we're
okay?
expecting.
Then they can file this thing.
Yes, definitely.
Obliged.
We don't have any remedy after the disposal.
Item 2.
May I, Your Lordship?
Yes.
The present criminal petition is filed under Section 528 of BNSS, bringing this honorable court to for the reduction of Zima Namabon, which was passed by the learned judge special court NDNPS by order dated 1st August 2025. The amount imposed was 15 lakhs.
What is 15 lakhs?
15 lakhs for Zima Namabon.
Bond.
Yes, my lord.
What is the seized amount of contraband substance? What was seized from the vehicle?
Heroin, which is 1.902
1.902
kgs.
kgs of heroin was
Heroin.
seized from the vehicle.
Yes, my lord.
Is it a hidden compartment in the vehicle or what? Truck? Let me just see here this thing. Huh. On which part of the vehicle was the heroin kept?
It was
From which part of the vehicle? Is it mentioned?
it was not mentioned, my lord.
Any idea?
I have no idea.
You are the owner of the vehicle.
Yes,
Is
my
it?
lord.
And right now you are in custody or
No, he is on bail.
you are released on bail? Okay. While you're on a bail, you want your vehicle also to be released, is it?
Yes, my lord.
We'll issue notice. Let's see. There must be some reason as to why the trial court had insisted on such a huge amount of bail bond. I'm just curious. 15 lakhs is a huge amount.
Yes, my lord.
So maybe there were some hidden compartments. The drug was specially manufactured. Anyways, we'll see that in the next date. We'll issue notice first. Yes, heard, miss?
Lalming Liani.
Okay, who is your senior?
JH from Neimoya.
Heard, Miss Lalming Liane, learned counsel for the petitioner, who has filed the instant petition under section 528 of BNSS, 2023, praying for the reduction of the Zimanama bond to be executed by the petitioner by the order dated 01/08/2025, passed by the learned Judge Special Court NDNBS Act, 1987, wherein the learned court had allowed the release of the truck bearing registration number, where is it? Where are the details?
Registration number
Where have you
AS.
mentioned page?
Page 36, my lord. Annexure 10.
You should have just mentioned it in your synopsis also. It would have been easier, isn't it? Page
Page 36, Annexure 10.
26,
36.
36. You should have mentioned it in the application also. It's not here. You have to look at the judgment and order of the court to find out. Isn't it? It's in the memo. So I'm looking at your application, not the judgment. It's not here. In your synopsis, it's not mentioned. In your application also, it's not mentioned. Let me just see your petition. If it's mentioned here. Yes, it's in page 5 of your petition. Okay. Bearing registration number AS 28 AC 1618 with a bail bond of rupees 15 lakhs. Is
Yes,
it?
my lord.
To the petitioner, who is the rightful owner of the said vehicle. The instant petition is filed for reduction of the bond amount, which is, according to the petitioner, too high and cannot be met by the petitioner. Yes, issue notice to the respondents. Ms. Vane Siame, learned additional PP, accepts notice on behalf of the state respondents. List after 2 weeks. 2 weeks, minimal requisite copies of the petition to be duly filed to the learned additional PP. Yes.
My lord, if the date may be fixed.
On after 2 weeks and date.
Maybe
7th of October.
7/10/2020.
For admission, item 3.
My lord, in this matter, PCR is arrived
Alright.
and
Paper book required or no?
paper book will not be required, my
Not
lord.
required? Okay.
If-
It needs. Okay.
Yes, if possible, my lord, it may come up again on this coming Monday, so that we make an attempt to dispose of the matter.
Yes,
It's a
what's the
simple
matter
only.
about?
This is challenging of the rejection or the rejecting the application for amendment of the plaint by the learned trial court, my lord.
Amendment
Yes.
of the plaint.
Yes. We prayed for amendment of the plaint that was rejected by the learned trial court, saying that the
Okay.
trial had already started, but actually it didn't start it yet.
Can be taken up on Monday, my lord, if possible.
Okay, Mr. Bilal Ramega, learned counsel for the petitioner is present, along with Mr. C. Tiang Lima, learned counsel for private respondent number 5, and Ms. Lan Nun Lui, learned government advocate for respondents number 1 to 4. It is seen that TCR has arrived. In view of the above, as prayed for, list the matter on, what's Monday's? 15th, 9/2024.
Much obliged.
Item 4.
No, on 15, 9 will be for admission hearing. For admission hearing, okay? Yes.
May it please your lordship, on behalf of the state respondents, we have filed our affidavit in opposition on the 25th of August 2025.
You have filed a counter.
Yes, your lordship.
And we
Yes.
have received it. Hello.
Do you need to file your this thing rejoinder
We will
or not
file
required?
a rejoinder. It
You
can
want
be- No,
Okay.
my lord.
Mr.
El Sanki Morality on behalf of
Lal
the
Sanki Maralte appears on behalf of his senior Mr. A.K. Rokum, learned counsel for the petitioner. Full stop. Ms. Lal Nandui, learned government advocate, submits that they have filed their counter affidavit. In view of the above, it is submitted that pleadings are complete. Accordingly, list the matter for admission hearing.
Your lordship,
After-
after the vacations, your lordship.
Is there any urgency in the matter? What is the matter about?
Is it regarding the claim of payment with regard to
Payment?
their work? With regard to their works.
Okay, no, the press, this thing. Okay, in view of the above, list the matter after the ensuing vacations.
Much obliged, your lordship.
Item 5.
For admission hearing.
Lordship, I'm appearing on behalf of respondent number 1. May I seek another 3 weeks' time for filing affidavit?
Wait, okay, not willing to have you, yes. So, counter,
Yes, my lord.
Your lordship, same prayer for the state respondents as well.
have you contacted the concerned authorities?
Yes, my lord. But we have not yet received instruction.
Okay, Mr. S. Vanisheta, learned counsel for the petitioner is present, along with Ms. Baby appearing on behalf of Ms. Zairam Sangpui, learned CGC, for respondents number 1, and Ms. Lal Nuntui, learned government advocate for the state respondents. The learned counsels for the respondents have prayed for further time to file their counter affidavits. In view of the above, list after 3 weeks.
Highly obliged. Item 6.
May it please your lordship, on behalf of the state respondents, we are yet to receive the affidavit, the pairwise comments, so if 3 weeks' time will be granted, your lordship.
What about the others?
Lordship, similar prayer for respondent number 4.
4. And 5 and 6?
My lord, similar prayer. Appearing on behalf of my senior, Mr. Samuel Vanisheta, standing counsel for NHIC.
Ms. Malsomi, learned counsel for the petitioner is present, while the learned counsels for the respondents. Okay, we'll just make it that have all prayed for time to file their counter affidavits. In view of the above, list the matter after 3 weeks.
Item 7.
Lordship,
Your Lordship, although this is fixed for the first time today, Your Lordship, the leading counsel, who is supposed to be the leading counsel, Mr. Victor, Your Lordship, has just informed me this morning that he's not able to show up today.
Okay, we'll list some other day. It's an appeal.
Yes, Your
Mention
Lordship,
is made on
if this
behalf
can be,
of,
Your Lordship, if this can be listed on Monday.
mention is made on behalf of Mr. Victor L. Ralte for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulty. In view of the above, as prayed for, list on 15/9/2025.
Obliged.
Item 8.
Yes,
Yes, my lady, this application is for condonation of
on donation of
Condonation.
delay, how many days?
210 days.
Yes, so
Yes.
objection is
And,
filed? Huh.
Yes, my lord, I filed my objection.
Yes, what is the reason?
The reason is that the appellant was not well. What's important to note, my lady, is that she's a widow. She has no support system, and she has been in legal battle with her in-laws for many years. Kindly have page 11 of the application. That's the medical diagnosis.
12. Sleep disturbance.
Yes, low confidence, low self-esteem, palpitation, tightness in chest, emotion, crying spells, low mood and interest in daily activities, fear of impending doom, and the stressor is property dispute, etc. And she is on medication because of these mental problems. And the following page is the second diagnosis. Follow-up case of mixed anxiety depressive disorder, and goes on to say on regular medication, and the symptoms again now: shortness of breath, palpitation, tightness in chest, fear of impending doom, anticipatory anxiety, low confidence, apprehensive, low interest to everything, and low energy. And the medication goes on. And my lady, what's important to note is that this lady lives alone in that house, surrounded by her in-laws, with whom she has been fighting legal battles. Now, a person who has hypertension and mental stress of this sort was not in a position to agitate her case. And what we are looking for is sufficient cause.
Okay. Yes.
And I will just read some.
Authorities, what do you have to rely on?
Yes. The first case is 1987, Volume 2, SCC 107. And this talks about sufficient cause. And if I may just read out, the expression sufficient cause employed by the legislature.
Read the para, the
Yes,
concerned para.
it's the first page, because this it's not paragraph. This judgment is not paragraphed.
How come? Of course it's paragraphed. It's there, para 1, 2, 3, everything is there.
No, the portion I'm reading
That
is not
portion is
paragraphed.
done by the law clerk. That's just a summary. Read the
So paragraph 1 reads, ordinarily, a litigant does not stand to benefit by lodging an appeal late.
where
Refusing
are
to
you
condone
reading
the-
from? The summary
collector
made
land-
by the law clerk, don't read that. Read the contents of the judgment.
I'm reading from the judgment, my lady.
Where?
Paragraph 1.
1. 1 is to condone or not to condone, is it?
No, that's the problem with these copies sometimes, my lady. Anyway, if I may just read it out, it's very short and simple.
Just see on top. Yes.
So, refusing to condone delay can result in meritorious matters being thrown out at the very threshold
The beginning.
and
The beginning.
cause of justice being defeated.
Anyway, you read the gist, isn't it?
Yes,
Which you're reading from SCC, isn't it?
yes, SCC.
SCC, then it should be the same. Just go on top, It's the last portion or the beginning?
No, it's at the beginning. Let me just double check, my lady.
The summary, it says that 2 days delay. Only 4 days. 4 days delay in filing the appeal concerning that. Then, anyway, so which portion?
So
of
the portion I'm
judgment?
reading is, because in my copy, it's paragraph. It's shown as paragraph 3.
3, okay.
Yes,
Paragraph 3.
it says every day's delay must be explained. Does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner.
Okay, yes, okay, the bottom part. Yes, okay.
When
Para
substantial
3, sub para, okay, para 3, then the sub para 3. Yes. You're reading for para 3,
Yes.
sub para 3, because 1, 2, 3 is there again, isn't it? Yes, okay. Yes, please go ahead.
So, should I start again? or-
Yes, please, yes.
So, ordinarily, a litigant does not stand to benefit by lodging an appeal late. Number 2, refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. Every day's delay must be explained does not mean that a pedantic approach should be made. Why not every hour's delay, not every second? The doctrine must be applied in a rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of a non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so.
Yes.
And I think I've provided 2 more judgments. The second is (2000) 2023 10 SCC 531. Then I'll read from para 30.
Yes.
Considering the aforementioned decisions, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and the state are not defeated at the threshold simply due to technical considerations of delay.
2023 10 SCC 531.
Yes. So, in a nutshell, what this judgment says is that there's a difference between an excuse and sufficient cause. Now, in the case at hand, there's a person who's living alone, who's a senior member of Obviously, she's quite aged.
Obviously,
Nearing
how old
70
is
years
she?
away. If I'm not mistaken, it's 67.
67 is not so aged. Anyways, go ahead.
Oh, but 67 with hypertension, living alone, mourning her husband's death.
She's not hospitalized, is she? She's in her house.
No,
Oh,
no, she's
okay.
in the house.
Oh, okay. Yes. Any other? Next
And
judgment?
yes, the third judgment is AIR 2005, Supreme Court 2191.
Yes, para?
Yes, para 8. The proof by sufficient cause is a condition precedent for exercise of extraordinary restriction vested in the court. Now, this is important. What counts is not the length of the delay, but the sufficiency of the cause, and the shortness of the delay is one circumstance to be taken into account in using the discretion. In N. Balakrishnan versus M. Krishnamurthy, it was held by this court that Section 5 is to be construed liberally so as to do substantial justice to the parties. The provision contemplates that the court has to go into the position of the person concerned
State
and
of
to find out in
Nagaland,
detail.
yes.
Yes.
Okay.
So that makes it very clear. So if we apply all these tests to the present case, the appellant does not stand to gain any advantage because of the delay. And was she prevented from actively pursuing her case? The answer would be yes, because there is zero support system in her life. In fact, I've mentioned it in my application, it's only when members of the church came and took her for counseling, etc., that her condition improved.
Okay. Yes. That's it? Opposite party.
May I
Yes,
please, Your
that's the
Lordship?
long and short of it.
May I please, Your Lordship? My Lord, I have submitted my written objections, wherein I have stated that the explanations put forth by the applicant, my Lord, these are not reasonable explanations. And in fact, these are not explanation. In fact, these are only mere excuse, my Lord. And I have also contended that the applicant had approached this honorable court with unclean hands. In fact, because, my Lord, Your Lordship will see that she had stated that she had suffered from hypertension after receiving the impugned, what has been impugned by the applicant.
Okay, wait. When was the judgment passed? The judgment and order was passed on?
The
one which
judgment
we-
was
18
18/12/2023.
December 2023.
Yes?
18/12/2023.
Okay. And the RFA is sought to be filed on when? Not yet. The
Date is not given, ma'am.
this thing, IA, was filed when? Anyways, it's an
In the affidavit, it says 25th October 2023.
25th
24.
11.
25th October 2024.
Okay.
This is the date given on the affidavit.
Yes. Okay, so you're saying that not with clean hands. Why?
Because, my Lord, the applicant had claimed that she had suffered hypertension after receiving this judgment and order impugned by the applicant. And also in support of that, the applicant had submitted medical documents, which are annexure number 1 and annexure number 2, page number 12 and page number 13. However, Your Lordship will see at page number 12, annexure 1, at the very top, the applicant had in fact been off her medication for 5 months prior to this 31/01/2024. It says,
Where? Wait.
it says, page
You're
number
referring
12.
to the documents submitted by them, isn't
Yes,
it?
my
Not
Lord.
yours.
Yes.
1 minute. Let
Page
us
number 12.
be on the same page. Then it's
Page number 12 of the application.
12, yes.
Yes.
12 is dated 31
31 2021 24. At the very top it says KCO MADD. This MADD has been explained in the next page. Page number 13. It is mixed anxiety depressive disorder. And here it says that she has been off medication of MADD for the past 5 months. So, my lord, this clearly reflects that the applicant has not approached this honorable court with clean hands. In fact, she had lied that she had been suffering even prior to the judgment and order impugned by the applicant was passed, man. And
May I reply, my lady?
and my lord, regarding the information being lately given by her counsel in the trial court, in this regard, I have stated at paragraph 2 of my objection that it is the case of the applicant that she had approached her counsel in November 2023. In November 2023. However, on that day, on November 2023, this impugned judgment and order has not yet been passed, man. And thereafter, the applicant had stated that she could not consult her counsel because of Christmas activities and Christmas shopping. Now, will that constitute a reasonable and sufficient explanation, my lord, that she has not been able to pursue her case due to the mere fact of Christmas shopping?
Okay.
And in support, my lord, I have submitted 3 rulings.
Yes.
The first, I would like to rely on 2024 SEC Online SC 513. This is in the case of Pathapati Subbareddy versus Special Deputy Collector. This speaks about Section 3 of the Limitation Act. It says that the Section 3 of the Limitation Act should be construed strictly. Paragraph number 9.
Yes.
Paragraph number 9, if I may read. Section 3 of the Limitation Act in no uncertain terms lays down that no suit, appeal, or application instituted, preferred, or made after the period prescribed shall be entertained, rather dismissed, even though limitation has not been set up as a defense, subject to the exceptions contained in Section 4 to 24, inclusive of the Limitation Act. And I would like to take your lordship to paragraph number 14, 1-4. If I may read.
Yes.
It may also be important to point out that though on one hand, Section 5 of the Limitation Act is to be construed liberally, but on the other hand, Section 3 of the Limitation Act, being a substantive law of mandatory nature, has to be interpreted in a strict sense. Now, my lord, if I may take your lordship to paragraph number 26. Here the Honorable Supreme Court has laid down what is to be followed, my lord. Paragraph 26. On a harmonious consideration of the provisions of the law as aforesaid and the law laid down by this court, it is evident that, number 1, law of limitation is based upon public policy that there should be an end to litigation for forfeiting the right to remedy rather than the right itself. Number 2, a right or the remedy that has not been exercised or availed of for a long time must come to an end or cease to exist after a fixed period of time. Number 3, the provisions of the Limitation Act have to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. Number 4, in order to advance substantial justice, though liberal approach, justice-oriented approach, or cause of substantial justice may be kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. Now, my lord, even though some more points are given regarding this Limitation Act Section 3 to be construed strictly, I will keep at that. And my lord, the second, in support of my second submission, that the explanation has to be bona fide, my lord. There has to be bona fide explanation. I would like to rely on 2024 SEC Online SC 489. Union of India and Nader versus Jahangir Bairamji GG Boy. 2024 SEC Online SC 489. Paragraph number 26 and 27. Paragraph number 26, if I may read. The length of the delay is a relevant matter which the court must take into consideration while considering whether the delay should be condoned or not. From the tenor of the approach of the appellants, it appears that they want to fix their own period of limitation for instituting the proceedings for which law has prescribed a period of limitation. Once it is held that a party has lost his right to have the matter considered on merits because of his own inaction for a long, it cannot be presumed to be non-deliberate delay. And in such circumstances of the case, he cannot be heard to plead that the substantial justice deserves to be preferred as against the technical considerations. While considering the plea for condonation of delay, the court must not start with the merits of the main matter. The court owes a duty first to ascertain the bona fides of the explanation offered by the party seeking condonation. It is only if the sufficient cause assigned by the litigant and the opposition of the other side is equally balanced that the court must bring into aid the merits of the matter for the purpose of condoning the delay. Paragraph 27. We are of the view that the question of limitation is merely a technical consideration. The rules of limitation are based on the principles of sound public policy and principles of equity. We should not keep the words of Damocles hanging over the head of the respondent for indefinite period of time to be determined at the whims and fancies of the appellants. Now, my lord, if your lordship could kindly come again to the application for condoning the delay, my lord. The excuse, as I have stated, my lord, these are not an explanation. In fact, these are, my lord, only a mere excuse. They said that the applicant has said that since it is Christmas festival, I have to go shopping, I cannot pursue my case. Then again, she said that after hearing this judgment and order, I have suffered from hypertension and I have to be medically taken care of. However, my lord, that even that, my lord, that is on false submission. And again, if your lordship will see again the medical document annexed by the applicant in the application, my lord, even though the diagnosis are stated in several numbers, my lord, only all these things are being taken care of only by tablets, medicines. The applicant has not been admitted anywhere, and also the period from 31st January 2024 to 25th June 2024, no explanation has been given. The applicant has not stated what she had done in the months of February, March, April, and May of 2024. She has not given any explanation as to why she has not taken any step for preferring the instant appeal within this month's month. And the applicant has also not stated what medical treatment was administered to her during this whole period. This period of 5 months, man.
Okay.
And regarding the incorrect statement, my lord, I would like to rely on 2 judgments. The first one I would like to rely on
incorrect statements.
False statement, my lord.
False statements.
False statement. As a ground for that has been used, my lord.
So you're saying that the false statement is
Regarding,
which statement is false?
my lord, the applicant has stated that after receiving the judgment and order dated 18/12/2023, she had suffered hypertension.
Okay. Which para of her application? If
Para
you are
five.
saying it's
Para
a
five,
false
my lord.
statement, you have to
Para
point
5.
out.
Yes,
Para 5.
yes. That
Para
if-
5 false
para 5 of
statements.
the application, my lord.
Ah,
If I may read, para 5 of the application.
yes.
That as a result, my lord, the words are as a result of her shock and dismay on coming to learn of the impugned judgment, the appellant developed hypertension and paranoia. And
So she learnt about the impugned judgment only on 15 January, isn't it?
yes,
This is in para 4.
yes, in para 4, in the last sentence, she had learned of this impugned judgment.
15 January, she learnt about it.
Yes,
So because of that, she got hypertension or whatever.
Yes.
Hyper.
yes,
So your point is that the medical
yes.
is dated what? What is the medical?
31/01/2000.
So it
But,
develops
my lord-
slowly because of the shock.
My lord,
Oh.
on the very first line, it says KCO MADD of medication for past 5 months is given. Here it clearly reflects that the applicant was already suffering from this
Okay, okay.
MADD my lord, prior to.
But it must have triggered again because of the judgment.
But my lord,
Because of medication,
But my
then
lord-
because of the judgment, again her hypertension must have triggered.
my lord, the words used by the applicant at paragraph number 5, my lord.
Anyways,
Yes,
I'm
the
getting
word-
your point. I'm just
Yes,
point.
my lord,
Yes.
my lord. Regarding this, my lord, I would like to rely on 2008, volume 17, SCC 448. 448, paragraph number 12. Paragraph number 12. If I may read. The Law and Judiciary Department as early as on so and so to say within a period of 15 days from the date of the award of the reference court communicated its decision to acquiesce in the decision of the reference court and communicated the same to all the concerned, including the beneficiary of the acquisition. It is not the case that the executive engineer did not receive the said communication. Having received the said communication, the respondent did not act in the matter and initiated any steps for filing the appeals if it was really aggrieved by the decision of the reference court. There is no doubt whatsoever in our mind that the respondent made totally incorrect statement in the application filed in the High Court. We express our reservation as to the manner in which the public authority conducted itself in its anxiety to somehow get the relief from the court. Now, this I would like to rely on. In our considered opinion, incorrect statement made in the application seeking condonation of delay itself is sufficient to reject the application without any further inquiry as to whether the averments made in the application reveal sufficient cause to condone the delay. This I would like to rely. And the judgment of passed by the coordinate bench of this honorable court, my lord. In the case of IS Civil number 92 of 2023 arising out of RFA 26 of 2023.
But what is the incorrect statement here? Is it similar?
More or less similar, my lord. In fact, the applicant therein had used a false submission, a false ground for a reason to condone the delay, my lord. I would like to rely at paragraph number 15, my lord. 15. The applicant despite having knowledge of the heirship proceedings, sat silently and only when was asked to vacate the house, approached this court. The averment of the applicant that she did not have knowledge of the heirship proceeding cannot be accepted as a matter of course. In fact, it is abundantly proved that she had knowledge of heirship proceedings and lied before this court under oath to the effect that she had only heard about the heirship for the first time when she was asked to vacate the house. Now, this are, my lord, the facts involved in this particular case. Number 16. The conduct of a party seeking condonation is a relevant factor to take into consideration. The applicant has resorted to falsehood to somehow make a case for condonation. My lord, and if your lordship could see paragraph number 18, this IA was dismissed, my lord, because of this false submission, my lord.
Okay.
So, my lord,
Yes.
my humble submission is that the applicant has not made any sufficient grounds. In fact, the only grounds taken are merely an excuse, my lord. And also, due to the fact that a false submission, the applicant has come before this honorable court with unclean hands, my lord. This application is like, it is my prayer that this application be dismissed, my lord.
Yes. Anything in rebuttal?
Yes, my lady. As far as my learned friend's submission that we're just making excuses, I strongly object. Nowhere in my application have I said that the appellant could not meet her counsel because of Christmas shopping, etc., etc. What I have said is, and again, what needs to be remembered, the backdrop is that this is a lady with no support system. Now, as far as the Christmas shopping is concerned, it's there in paragraph 4. However, December being a festive season, the appellant's relative could not take out time as her own family was busy with Christmas festivities and shopping for the Christmas celebrations. So, what I am saying is, this relative whom I asked to accompany me to meet my legal counsel could not take out time because of the Christmas festivities that were going on in her house. I'm not talking about my own shopping. So that's a total red herring. And as far as the application, the medical certificate is concerned, 5 months of medicine would mean that previously her situation was better. But obviously she had to consult a doctor because her situation had deteriorated. And the diagnosis, unless my learned colleague is challenging the diagnosis of the doctor, a trained professional, the diagnosis is quite seriously sleep disturbances, low confidence, low self-esteem, palpitation, tightness of chest, emotionality, crying spells. So she became an emotional nightmare, again with no support system. So if this is not sufficient cause, then what is? And she continued with the medication for 6 months. And that's the second annexure, the follow-up case of mixed anxiety, depressive disorder. And there the diagnosis was again shortness of breath, palpitation, tightness of chest, fear of impending doom, anticipatory anxiety. We know what anxiety can do to people. Many people commit suicide. Just because a person is not better.
Yes. We'll not look into the medical so much now. We have submitted your documents, isn't it?
Yes.
I heard Mr. Lalam Sanga.
My lord, if I may add one small point, my lord. The medical the report that has been relied on
Private.
Yes, by my learned friend, it will indicate that, my lord, these medication are only for 1 month.
It's a private doctor.
Yes,
That's one thing I'm
only for one month. And then the applicant herself was silent thereafter, my lord. Till February, March, April, May, no step has been taken. Even no explanation why no step has been taken has been defined, my lord.
And this is a private doctor. That's this thing, because in the court, usually it's the government doctors that are looked into. Anyways, I'll keep the matter this thing.
Had the appellant known all of this would have arisen, she would have gone to civil hospital, my lady.
Okay. Heard Mr. Lalam Sanga Ngaka, learned counsel for the applicant slash appellant along with Mr. T. Lal Zikima, learned counsel for the opposite parties. Okay. And matter is considered. I'll consider your submissions and pass the order accordingly by next, within next week. Okay, since today is a Friday.
Item
Right,
9.
my lady.
Item 9.
Yes.
Lordship, as per the last court order, the that matter was to be listed after the preparation of the paperwork, Lordship. Although
So
we have
paperwork
not,
is ready? It's ready?
it's ready, but we, a copy have not been
received
furnished
a
to
copy
us.
yet. Okay. Ms. Malswamy, learned counsel for the amicus, is it? Ms.
Yes.
H. Malswamy, learned amicus curiae for the appellant is present along with Ms. Vanis. Siami, learned additional PP for the state respondents, and Mr. Lalrukuma Paugdu, learned legal aid counsel for the respondent number respondent number 2. Cancel the D. Okay, for respondent number 2. It is seen that since paper book is ready, copies to be duly served to the learned counsels. This is the matter for hearing in due course as its own. Okay.
Item 10.
Please, Your Lordship. Your Lordship, there is an application for substitution of the writ petitioner in WPC number 48 of 2023. The writ petitioner had died on the 15th of March this year. And this application has been made by
Substituted
his
by the wife.
wife.
Is it?
Madam.
And
Lordship.
the writ petition is regarding?
Writ petition is regarding easement rights over the LSC.
Okay, and she's now staying in the LSC.
She is now the heiress of the LSC. Heirship
Yes,
certificate.
so will allow government heard Mr. Vanlal Ngaka, learned counsel for the applicant who has filed the instant application. You make it interlocutory application under order 22 rule.
3.
You missed out the 3. Is it here? Let me see. Yes, rule 3, read with section 151 of the Code of Civil Procedure for substitution of the writ petitioner, Mr. H. Lal Tazova, who died on
15-3.
Wait, let me see.
15-3,
Is
2025.
the death certificate enclosed?
That certificate is at annexion number 1, Your Lordship, page number 8 of the application.
Yes. Who died on 15/03/2025 by his legally wedded wife, Ms.
Lal Nooni.
Lal Nooni, is it?
Yes.
Residence of?
Saron Wing.
Residence of Saron Wing, Aizawl. Ms. Learned Government Advocate is present and submits that they have no objection to the instant substitution application. In view of the above, this court find it fit to allow the application, and accordingly, Mr. So-and-so H. Lal Tazova, within brackets late, writ petitioner in WPC number 48 of 2023 is substituted by his wife, Ms. Lal Nunglui, a resident of Sarongling. Good stuff. Accordingly, IA so-and-so, IA 164/2024 stands allowed and disposed of.
If I may, Your Lordship, the permission may kindly be granted that we may be allowed to make the necessary changes to the writ petition.
Wait, disposed of. Okay, stop. Then on the disposal of the IA number 164 of 2024, the learned counsel for the applicant is to take steps for making the correction in in the connected WPC number 48/2023 by in the course title, okay, correction in the course title of the connected WPC 48 of 2023. Is notice required to be issued? No, you're the petitioner. Okay. And after the correction of the course title, the main WPC number 48 of 2023 in the next week?
Next.
In the next weeks for further necessary steps. Yes.
Obliged.
Hearing list, item 10.
Please, Your Lordship.
Limitation that I. Yes.
This MAC appeal is arising out of the judgment and order dated 5/7/2023, passed in MSCT 21 of 2009, passed by the MSCT ISOL, whereby the present claimant, respondent number 1, has been awarded an amount of rupees 31 lakhs 83,000, which is to be paid by the present appellant insurance company. Now, my grounds of appeal are, as far as the facts is concerned, Your Lordship, there is no dispute. It is duly
An
insured.
accident.
Accident occurred. There was a death. Policy is valid. Covered. We're not denying that.
Then?
We're filing this case on only 2 grounds. On 2, although I've raised some other grounds, but I'll confine it to 2 grounds only. One is on the issue of liability.
If the insurance is covered, vehicle is covered, accident vehicle is covered by the insurance policy.
Correct. Correct.
But you're saying that the insurance company is not liable because?
Yes, because premium was not paid.
Okay, not covered by the premium.
Correct. The issue is this, Your Lordship. The brief facts I'll just begin with. On 15/2/2018, at around 3 p.m., one tank lorry, duly registered with the present respondent number 2, Misofed, bearing registration number MZ058834, met with an accident at near Tlong River, Mausen in Lunglei district. There were 2 drivers. The first one is the present respondent number 3, who is in fact the employee of Misofed, and the deceased was the so-called second driver, privately employed by the driver of this accident vehicle, the valid driver, so to say. The present respondent, the deceased, the name of the deceased is Lalshiat Renga, whereas the respondent number 3, driver of the accident vehicle, is Mr. Lalni Thanga. He is employed by Misofed.
This is a MAC appeal, isn't it?
This is a MAC appeal.
Not to this thing, under employees.
Now, it is an
It's not
undisputed.
under Employees Compensation Act.
No,
Anyways,
it's not. It's not.
so-
It is an undisputed fact that the deceased Lalshiat Renga was under the employment in the private employment of this Mr. Lalni Thanga. It is an admitted fact. It's in evidence. If Your Lordship can kindly turn to the certified true copy of my judgment and order, we can come to para 10 of the internal paragraphs.
Okay, so he is employed. That's
Yes.
different.
So this Lalni Thanga has stated in his evidence that the deceased was employed by him in his personal capacity, and he used to pay him the 25,000 rupees as his monthly income. Now, My first contention is, as far as the liability of the insurance company is concerned, is between the insured and the insurer. I am the insurer. I have insured the Misofed and their employees.
Okay.
But this deceased was not under the employment of Misofed, and he was traveling in the vehicle. These are undisputed facts.
What is the nature of this thing? Insurance policy?
Yes, I've given a copy of the policy. It's a comprehensive policy, no doubt.
It's on the third party liability or
No.
nothing like
It's a
that?
comprehensive policy which covers pretty much everything
Okay.
as far as the vehicle and its employees are concerned. And I've highlighted that portion, the highlighted portion. Lordship, the liability, the coverage is here. First one is your basic TP, that is third party cover. LL is limited liability to persons employed for operation and or maintenance and or loading and or unloading, limited liability to paid driver, conductor, cleaner employed for operation. That means that paid driver of Misofed, paid conductor of Misofed, paid cleaner of Misofed, employed for operation.
Okay.
Unfortunately, it is in evidence that he is not the employee of Misofed. And it is in evidence of the driver, Lalnithanga himself, as well as the other claimant's witness, that he was traveling in the vehicle as a second driver, so-called second driver. And as I've just read out, there is no premium paid for second driver. And even if assuming but not admitting that he was a second driver, he will have to be under the employment of Misofed for us to be liable. That is our first issue. As such, considering the fact that he was neither a paid driver or a paid second driver or a cleaner or a conductor, he walks into the shoes of a gratuitous passenger because he was traveling inside the vehicle. A third party would mean that anyone who is externally struck by the insured vehicle. As your Lordship may recall, in many policies, you will have this premium for unnamed passengers. But
So you see, he is not a passenger.
he's not a passenger. He's a
He was driving.
gratuitous passenger. What is covered by this policy are those employed by Misofed. He is not employed by Misofed.
Okay.
That is an undisputed fact in evidence. In that respect, Your Lordship, I would like to place reliance on one small judgment of this Honorable Court, Coordinate Bench. This is MAC Appeal 46 of 2014, which was disposed on 11th of January 2024. Your Lordship may kindly turn to para 15 onwards. At page 7, para 15. Your Lordship has it? I apologize.
Yes.
In National Insurance Company Limited versus Srinivasa so-and-so, if the risk of an occupant of a car, inmate of a vehicle, or passenger in a private vehicle car is to be covered, additional premium has to be paid. If no additional premium is paid, the risk is not covered. The statutory liability under Section 146 and 147 of the Act has to be read with the terms of the insurance policy issued under 146 of the Act. But that does not prevent an insurer from entering into a contract of insurance covering a risk wider than the minimum requirement of the statute, whereby the risk to gratuitous passengers could also be covered. A third-party policy does not cover liability to gratuitous passengers who are not carried or for hire or reward. If a liability other than the limited liability provided for under the Act is to be enhanced under an insurance policy, additional premium is required to be paid. The liability is restricted to the liability arising out of the statutory requirements under Section 14 only. In the Oriental Insurance Company versus so-and-so, the law which emerges from the said decision is, the liability of the insurance company in a case of this nature is not extended to a pillion rider of the motor vehicle unless the requisite amount of premium is paid for covering his/her risk. The legal obligation arising under Section 147 of the Act cannot be extended to an injury or death of the owner of the vehicle or the pillion. The pillion rider in a two-wheeler was not to be treated as a third party when the accident has taken place owing to rash and negligent riding of the scooter and not on the part of the driver of another in the vehicle. So in the present case, Your Lordship, the liability was fastened based on the rash and negligent driving of the paid driver. This is not a case where they were struck by some other vehicle.
How did the accident occur?
According to the police report, the steering mechanism failed, as a result of which it swerved towards swerved off the road, basically.
Okay, off the road.
And this is what, and according to the statement of the driver, the paid driver, he said that it was his negligence. He survived the accident. He survived the accident, and he stated that it was because of my negligent driving, so and so. So we are not disputing that, because he was.
It was the driver who was driving.
Yes.
And then
He was
another
sitting in the
passenger.
vehicle.
So the one who died is the passenger.
Yes. Although in the evidence they called him a second driver, since he was not an employee of Misofin, he walks into the shoes of a gratuitous passenger. That is our contention.
Okay.
And 17 and 18 only, Your Lordship. In Tilak Singh and others so and so, in our view, although the observation made in Asha Rani's case were in connection with carrying passengers in a goods vehicle, the same would apply with equal force to gratuitous passenger in any other vehicle also. Thus, we must uphold the contention of the appellant insurance company that it owed no liability towards the injuries suffered by the deceased so and so, who was a pillion rider, as the insurance policy was a statutory policy and hence it did not cover the risk of death or bodily injuries to a gratuitous passenger. In the case of the United Insurance Company Limited so and so, considering the facts and circumstances of the case and the submissions made on either side, this court is of the view that Act policy covers the losses arising out of the persons stipulated in Section 147 of the Motor Vehicles Act 1988, and the said provision of the Motor Vehicles Act will not cover a pillion rider in a motorcycle, and therefore the insurance company is not liable to pay compensation, and this civil ministerial application is to be allowed. So our contention, again reiterating, is that since
he was not
he
a
walks
paid
into the shoes
driver.
of he has walked into the shoes of
gratuitous passenger. That's your
gratuitous
point.
passenger, and no premium has been paid, unfortunately.
Not covered by the premium.
Yes.
Okay. Yes.
That's point number one. As a result of that, since there is no coverage, we cannot be held liable. Our second contention, limited contention, is on the assumption, but not admitting, that he was not a gratuitous passenger, and that in fact he would be covered by the policy, on the assumption that we are disputing the income of the deceased. Now, the so-called employer, who is the present respondent number 3, has stated in his evidence that he was under his employment and he used to pay rupees 25,000 every month. Now, had it been any other situation, because in MACT, obviously, we rely on the principles of preponderance of probability and not the strict rules of evidence. I understand that. I accept that. Had it been any other situation, I would have not disputed that. Unfortunately, in the present case, Your Lordship, this is the third round of MACT which they have filed. And in every application, the income is different in the application form.
Where the other applications?
Yes, in my written statement, unfortunately, I did not annex the entire annexures of my written statement, but I believe the trial court records are here. I think my WS can be.
You're saying that previously he had approached.
I annexure.
Then what happened to the first application?
It was withdrawn with liberty to file.
Okay, withdrawn.
Yes. So that was the situation.
So if it's withdrawn, it's withdrawn. It's not considered.
No, that is fine.
Oh.
The rights to file is definitely there. That I am not denying. What I am saying is that how did his income magically differ every time? That is what I'm saying. My written statement in the MAC appeal is at page 56, annexure 6. The relevant page. Sorry, this one is 2019. I apologize.
Now
It
you're
is
disputing
at
the
page
income, isn't it?
Yes, they're saying that
25,000.
25,000.
So no income certificate
Nothing.
and
No bank statement.
so no income certificate, and then it is claimed by his wife, most probably, that his
No,
income
sister.
was 25,000.
Sister. Initially, it was the father, But during the pendency of the case, he passed away and he was
Okay,
substituted
so
by
he was
his
a bachelor when he died.
bachelor.
Okay.
So at page 59, annexure 7 is my written statement, Your Lordship. At page, in the next page at 60, at page 61, para 12 of my written statement. 11 onwards. 11, it may be humbly submitted that here in the instant claimant had previously filed MACT, they had filed it in Colossi. So and so, before the special judge fast track court, Colossi, which was disposed of on withdrawal with liberty to file a fresh right ordered number, so and so. That the instant claimant had filed MACT 53 of 2018 under section 163 of the motor vehicles before the owner case, wherein the income of the deceased Lakshya was taken as per notional income at para 6 of the claim form. However, perusal of the para 6 of the instant claim form would reveal that the income of the deceased Lakshya has been calculated rupees 25,000. That the claimant has contradicted himself as to the income of the deceased Lakshya, that the claimant has not come to this honorable court with a clean hand but tried to mislead this honorable court, so and so. So, just to, in the first application, which was registered as MACT 53 of 2000.
Anyway, so maybe it was because then they could have discovered that this was a mistake. He's having a proper income, and
No,
then
no,
they
no.
have withdrawn.
If I
and
may.
then 25,000
No,
is this income. So you have to prove the
is-
25,000.
no, that is not possible. That would not be possible. The reason being is that it is in evidence that the
Well, why did he withdraw? He must have withdrawn because maybe, I'm just saying, for the
Right.
sake of, maybe it was filled up by someone else and then.
No problem.
No. So now he's claiming that the correct, I'm now submitting my application again because my correct income is 25,000. But he has to prove this 25,000. I'm just
correct,
in the court, how was it proved that his income was 25,000?
apart from the statement of the so-called employer respondent number 3, there is no other information.
And respondent number 3 is the driver.
The
Yes,
driver, the paid driver of Mizofed, who had privately engaged the deceased. So, I beg to differ on your lordship's premises. The reason being is that number one, your lordship's premises was that they might have discovered this new information at a later stage. I think there's a slight flaw in that vis-a-vis the facts of the case. Because number one, the case was filed by the father. In all occasions. In all 3 occasions, it was filed by the father, R. Alkoga.
Okay, so the first time it was notional income, second time 25,000, is
Right,
it? The
right.
third time?
I'm not aware about the first one, which was in Colossi.
Okay.
That was notice had not gone because
Okay, so
they had approached the
Colossi-
wrong forum, realizing that they immediately withdrew it.
So when it was filed in Colossi, maybe it's 25,000, you don't know. Anyways,
No,
anyway,
if
so
your lordship can
notional
ki-
income,
if your
then
lordship
third-
can kindly
just
hear me
that's
out.
for the, yes.
If
yes.
your lordship can
Yes,
kindly
yes,
hear me
yes.
out. The claim was filed by the father. Now, if they had lived in a separate location, then definitely what your lordship said would make sense. But it is in evidence that they all live together under the same roof. And they're saying that we are solely dependent on the income of this person. So he would have known. How can he say that I did not know that my son was earning? And I did not know that he was a driver. That would contradict the recorded evidence, your lordship.
No, but I'm just saying, if it was withdrawn, there must have been a reason for withdrawal. Well, let's look at the ground reality, okay, where the people are uneducated and people just fill up their forms like this. Is he a government servant? No, then must be notional. That could happen. I'm just saying it's happened here. What happens, ground reality is different from what the documents say. So then they realize, oh, the income has been filled up wrongly. Let me take it out and give the correct income. It could be that, but they have to prove their income. That's what I'm saying, 25,000 before the tribunal, that has to be proved.
Right.
So you're saying that the evidence before the trial court regarding the 25,000 cannot be accepted because the respondent number 3, who is a driver, is giving 25,000, which is not possible.
Which is not
A
possible.
driver's pay. Okay.
It's
Yes.
quite exorbitant, number one. Number two is that there is no documentary evidence. I'm not saying that you give some concrete evidence, but at least show some back
Something.
statement saying that, look, around this much amount is being withdrawn from my account every month, so and so. I mean, certain.
Yes, no sufficient evidence, so ultimately notional income has to be
And
taken.
normally, as I understand that, especially in since they are all residents of locality, especially places outside, even in Aizawl for that matter, normally cash transaction happens. Right. So had they not filed the previous case where saying that they don't have any employment and that they're claiming as per notional income, I would not have harped on this issue that much. But since there are contradictory claims on so far as the income is concerned, that's why the degree of proof has slightly increased.
Okay, yes.
So that's why in our humble submission is that if at all liability is to be fastened on the insurance company, it should be taken as per the Minimum Wages Act. And we are agreeable to the 2023 notification, considering this is a continuation of the case.
So skilled.
And as skilled number one.
What is the income?
It's 510
Per day.
per day.
Okay.
That public motor transport employees, skilled one, even by taking that, since it's a tank lorry, it will require a sufficient amount of skills. So
Okay.
if at all any amount is to be awarded, it should be as per this notification. That is a limited submission, Your Lordship. I have one more point, but what happens is one of the claimant is the sister. Now, I think my learned friends also know very well that unless there is evidence to the contrary, brothers and sisters are not supposed to be considered to be dependents. But since he's a bachelor anyways, I will not press on that. So with that, Your Lordship, number one is that no premium was paid as far as
Does not cover him. Huh?
Yes, he's not one of the employees of our insured. As such, he walks into the shoes of a gratuitous passenger. He cannot be covered. No premium paid, so no liability. Second is that if at all liability, it should be as per the Minimum Wages Act. That is a sufficient, limited appeal. DPO
Yes.
Well, please, Lordship. Lordship, my learned friend had clearly narrated the story of the case, and the admitted fact is that the insurance policy was valid at the time of the accident. It is not
That's
disputed.
Not disputed, huh?
Yes, it is
Are
not
you
disputed.
covered by the premium? Huh?
Yes, Lordship, regarding the argument projected by my learned friend regarding the deceased, who was the second driver of the accident vehicle, was not covered by the insurance policy. Lordship, in this regard,
To be the second driver, you have to be paid by the the company, isn't it?
Lordship, that was paid by the this respondent number 3, who is the driver of the Mizofet.
With the knowledge of the, or with the permission of the Mizofet or no? Are they aware that you
Lordship,
are
that I cannot
sub-employing
answer.
someone else?
that I cannot answer here. My learned friend is there on behalf of the Mizofet. Lordship, that may be the
Can
answer
you
by my
actually
learned
go and
friend.
involve someone else? Is that proper?
Lordship, may take Lordship to the page 56. Page 56 of the appeal memo, Lordship. That is the written statement submitted by the insurance company, the appellant, Lordship. And this is a 2-3 page only, Lordship. I've gone through this written statement submitted by the insurance company, Lordship. However, so the grounds taken by the appellant that no premium was paid to the second driver was not raised before the tribunal. That was not raised at all, and even in the this evidence also, it is not
How
supported.
can you call him a second driver? Was he the one driving the vehicle?
He's the one who's, at the time of the accident, it was driven by the respondent number 3.
So he's another passenger. How can you say he's, anyway? So
He's the employed of the respondent number 3.
but not the company.
Not the company, Lordship. That is the, yes. Company did not employ him.
If the company did not employ him, he can do any. I mean, how can you say he's anyways?
Lordship, here, after going to the written statement, and nowhere in the written statement raised that a premium was paid to the deceased. That was not raised before the tribunal, Lordship. And the appellant may not be permitted to raise that grounds
Okay,
in the appellate
before the
stage, Lordship.
tribunal, huh.
Yes, yes. And in this regard also, there are so many judgment. Your Lordship also passed several judgments. So I will supply to this honorable court. And Lordship may take Lordship to page 27. Page 27. Page 27, paragraph number 5. There are 3 issues framed by the learned tribunal, Lordship. Here it says the following issues were framed from the pleadings of the parties. Lordship, there are 3 issues were framed from the pleadings of the parties. Lordship, that regarding the argument projected by my learned friend was beyond the pleadings. So that is the reason the tribunal did not frame in the issues for the consideration. So the 3 issues are very clear and which were framed by the tribunal, Lordship.
Okay.
So, and
What are the issues?
there are 3 issues. Number 1 is whether the claim application is maintainable in its present form and style. And the second one is whether there was fault on the part of the driver or owner of the accident vehicle. And the third one is whether the claimant is entitled to compensation, and if so, to what extent, and who is liable to pay. And based on the 3 issues framed by the learned tribunal, evidence was
What does
well
issue
adduced.
number 2 mean?
Issue number 2 is whether there was fault on the part of the driver or owner of the accident vehicle.
It was driven by the driver. How can it be the owner of the accident vehicle when the driver was driving the accident vehicle itself, isn't it?
Also, that is the issues framed by the learned tribunal. And
but-
based on
but
that
Why is
evidence,
this issue framed? I'm just asking. It is on the fault of the driver. So what would be the fault of the owner of the accident vehicle?
owner of the accident vehicle is the middleman, and if it is the fault of the driver, a paid driver, and that will goes to the owner. Then if the owner validly insured, then that will goes to the insurance company.
So the fault on the part of the driver. The driver is
on the
driving,
part of yes, on the
or
part of the
owner.
driver.
So what will be the fault of the owner of the accident vehicle?
Lordship, in that case also,
I'm trying to understand the issue from the pleadings. Owner of the vehicle is Mizofed. The driver dies. So even if it's in the fault of the driver, if it is
Also, the
covered,
driver-
if it's insured,
Also,
then
yes.
it will still be, if it's so,
if it is if it is the fault of the driver, and that will goes to the owner, and if the owner validly insured, then that will goes to the insurance company, Lordship. And that was the findings of the tribunal also.
okay.
That was the findings of the tribunal. And Lordship, what I'm trying to stress upon this this paragraph is that these 3 issues were framed from the pleadings of the parties, and the argument projected at this belated stage was not raised at all, and even in the written statement submitted before the tribunal, that was not raised before the tribunal, Lordship. And moreover, Lordship, if there was no documents exhibited from the part of the appellant, this the insurance company, to show that extra premium needs to be paid, Lordship. No evidence was
document. This
Yes.
document is produced only here.
Produced by the these claimants before the tribunal, and they did not produce any this material evidence to show that the this extra premium needs to be paid, and that was not the stance taken before the tribunal. at all, Lordship.
Okay.
And regarding that, we take Lordship to
What was the insurance policy produced before the court, before the tribunal?
before the tribunal is Lordship.
What are the exhibits?
Exhibit C. Oh, sorry.
Trial court report was called for. What was exhibited?
C1515, Your Lordship.
C15 of what? Which page are you referring to? C15 in the statement. So for same premium,
Same
thing as here.
That was, Lordship, that
Limits,
was
no limits of liability. Let's see. Basic. Same. What is been produced was also produced before the trial court.
that was exhibited by the claimants, Lordship.
But that point was not raised. You're saying that you.
Yeah, that point was not raised before the tribunal
okay.
because the appropriate forum is the tribunal, Lordship, because this is the appellate stage. And in that regards, we take Lordship to this make appeal number 374 of 2016, which is passed by Your Lordship. Paragraph number 18. Paragraph number 18.
Yes.
Married Lordship. It is also noted that there is no plea taken by the present appellant that they were not given a chance to cross-examine the deposition made by CW number 1 and CW number 2 before the learned tribunal. Lordship, here also there is no plea taken by the appellant that the deceased is not covered by the policy, Lordship. So it cannot be a grounds at the appellate stage, Lordship. And Lordship,
Do you have any other authority? This is a different context when this thing was made.
Lordship, in that 375 of make appeal number 375 of 2016, this is also passed by Lordship, which is at paragraph 14. Paragraph 14, Lordship. Having heard the submissions made by learned counsels for both the parties, this court has not. Yes,
isn't it?
yes.
So
And-
any other authority besides this? This is given a chance to cross-examine or not?
Lordship, yes.
It's different.
Lordship, another is 2024
Yes, the argument
STC.
raised by the councils is different, very different from what
But
is.
very different. But Lordship, the stance taken.
Anyway, let's see.
2024 SCC, this paragraph number 14, 1-4. Apart from the fact that none of the said substantial questions of law formulated by the High Court were either raised before the trial court or the appellate court, none of the parties were given any opportunity of leading the evidence on the said issues. It is well settled principle of law that the court cannot create any new case at the appellate stage for either of the parties, and the appellate court is supposed to decide the issues involved in the suit based on the pleadings of the parties, Your Lordship. So that is very clear. And Lordship, one more submission, which is 2000, this make appeal 214 of 2014. Lordship. At paragraph number Lordship 10, paragraph number 10.
Yes.
Last line, Your Lordship, last line. Had this issue, Lordship, got it?
Yes.
Had this issue been raised during the pendency of the claim, the rival parties could have opportunity to cross-examine the witness leading such evidence. However, as both claims have already been disposed of, I am of the view that the same should not be reopened at this stage. Lordship, if the appellant had raised that issues, then we could have opportunity to cross-examine the insurance people also, Lordship. But that was not raised before the tribunal. Lordship. And Lordship, and regarding the income, my learned friend had stated that the income was not proof. Lordship, the income was issued by the employer of the deceased, which is exhibit C3. Lordship, and the employer is also called before the tribunal and he deposed before the tribunal. And his evidence is also not shaken. And there is no rebuttal evidence on the part of the insurance company, Lordship. And that has been clearly reflected in the judgment also. And the income certificate was exhibited at Exhibit C3 without any objection.
Now let's see the evidence
Yes.
of respondent number 3 here. What did he say?
At page 34, paragraph number 10. Page 34. May I read, Your Lordship?
Yes.
OP number 2, Lalni Thanga, son of such and such, examined himself as witness who stated that though the tank lorry was registered in the name of OP number 1, however, he is the real owner of the said vehicle. It was registered in the name of OP number 1 due to the fact that due to understanding and as per understanding between OP number 1 and the tank lorry which transported
Okay, so the driver was the real owner of the vehicle. Is
Lordship,
it?
yes.
Okay, anyway, due to her. Please read her.
Due to the fact that due to understanding and as per their understanding between OP number 1 and tank lorry which transported the petroleum products which were registered in the name of OP number 1, he is a driver by profession and owner of the accident vehicle. He drove the said vehicle at the time of accident and holding valid driving license Exhibit C8A and at the time of the accident. The deceased Larshia Dringa was employed working under him as a tank lorry driver. He used to pay his salary as per transporting the said petroleum product by driving the said tank lorry. His salary was in between 3,000 to 5,000 as per the distance which he had transported the said petroleum product, etc. by driving the said tank lorry. In a month, he used to transport the same from 5 times to 7 times. His average salary is 25,000 per month. He admitted that the cause of accident was due to his carelessness as he knew beforehand there were problems in the steering in the said vehicle frequently and he used. The accident vehicle was validly insured with the OP number 3 as per the understanding and all other documents were valid at the time of the accident. He identified Exhibit CA is his signature and Exhibit C8A is driving license. In his cross-examination by counsel for the OP number 3, he admitted the questions that he being carrying a contract with the OP number 1, his vehicle, tank lorry, bearing registration numbers as said, is registered in the name of OP number 1 and that all vehicular documents including Exhibit C9 is in his possession and that all the vehicular taxes payable by the oil tanker that is M0 is paid by him. He stated so far as his knowledge is concerned, all the vehicular documents including his driving license, which is Exhibit C8, are valid at the time of the accident. He also admitted the suggestion that he was in a good physical condition on the day when they have met with an accident on 15/02/2018 and that deceased Larshia Dringa was under his employment as a driver for the past 1 year prior to the accident and that they usually travel for the OP number 1 for not less than 5 times every month and that he never made furnished payment receipt to the deceased Larshia Dringa while he was under his employment. He also admitted the suggestion that the permit for driving hazardous vehicle is not reflected in his driving license Exhibit C8. He denied the suggestion that his driving license at Exhibit C8 is fake driving license. He agreed with the police verification report at Exhibit C8 that the cause of accident was due to steering failure and the PO was sliding uphill and that he was running at a slow speed. He denied the suggestion that Larshia Dringa did not die due to vehicular accident even though his vehicle is registered and insured in the name of the OP number 1. He cannot deny the liability of the insurance company towards him. He admitted the suggestion that he was sober and not intoxicated at the time of the accident. So he had issued this income certificate and which is exhibited as Exhibit C and not objected, and there is no rebuttal evidence of the income of the deceased from the appellant, And in this regard, I would like to rely upon the coordinate bench of this honorable court. May take lordship to make appeal number 36 of 2017. Lordship, the operative is at paragraph 11. Lordship, may I read? On the first contention of the appellant, it may seem that the respondent claimant examined herself as claimant witness number 1, stating that her examination in chief that her husband complete electronic training course on such and such from Electronic Institute to Adjournment, Manipur. He was employed by Mr. such and such at a monthly salary of, and that she, her husband, and the 2 minor sons were all depending on the said a monthly salary. She also deposed that her deceased husband was aged 36 years at the time of his death, and that the claim of rupees 27 lakhs 10,000 and the other admissible amount under law as compensation for the death of her husband. The respondent claimant also examined the proprietor of 3 Brothers Technical Works as claimant witness number 3. The said proprietor, whose name was such and such, deposed before the tribunal, stating that he employed the late husband of the respondent claimant as an electronic technician by paying monthly salary of rupees 12,000. He also stated that he issued the income certificate of the deceased and exhibited the same as Exhibit C21. In his cross-examination, he reiterated the fact that he employed the deceased person and paid him a sum of rupees such and such. The appellant, lordship, the appellant, on the other hand, did not adduce any evidence to disprove the fact that the deceased person did not earn rupees 12,000 per month. In fact, income certificate issued by the claimant witness number 3 was admitted without any objection, and it has been duly exhibited by the respondent claimant, lordship. Here
So
in our
income certificate was also issued in the instant case?
yes, your lordship.
There's an income certificate?
Yes, your lordship, which is at Exhibit C3.
Okay. Yes.
And lordship,
Signed by what? The same respondent, respondent number 3?
respondent number 3, your lordship, and he deposed before the tribunal that he paid
okay.
this much of money. And lordship, that one more lordship citation. Make appeal number 3 of 2023. Make appeal number 3 of 2023. Lordship, paragraph number 13. And lordship, the operative is at page 11. 4 lines from the top, your lordship. 4 lines from the top. Insofar as insofar as the monthly income of the deceased is concerned, CW number 3 not only issued a certificate to the effect he employed the deceased person as his driver to drive the taxi by paying such and such per month, but he also testified the same before the tribunal on oath, and he was also subject to cross-examination. As already stated, his testimony has not been rebutted or nor falsified by the opposite parties, including the instant appellant. Under the circumstance, there is no reason to interfere with the amount awarded by the tribunal based on the monthly income of rupees 15,000 earned by the deceased person. Lordship, in our case also, the person who issued the income certificate was called before the tribunal. On oath, he deposed, and he also testified, and he was also subject to cross-examination, and there is no rebuttal or falsified by the opposite parties, lordship. So, lordship, there is interference of this court is not warranted, lordship, and the tribunal had rightly passed this judgment and award, lordship.
Okay.
Lordship, most of the points which I was also trying to make has been submitted by my learned friend for the respondent number 1. And in addition to all those submissions, I would like to make one submissions regarding, it has been submitted already, but I would like to elaborate slightly on that point regarding the issue of premium, whether paid or not.
Premium. Yes.
I would firstly like to say that this in this appeal, where I can see the written statement of the appellant at page number 59. I was going through, but I could not find any of the ground which has been taken with regard to the premium.
Not raised before
it
the
was not
tribunal,
raised
isn't
before or
it?
otherwise not led in evidence. So in that fact of the matter, the other respondents, the respondents herein are not in a position to take a defense of that point where it was not raised at all at any point of time. So in the absence of such points being raised, the prejudice will be caused to the respondents at this stage. And for that matter, I would like to place one citation and would like to highlight one point with regard to a policy where policy is or a policy is in custody of the insurance policy, and if they would like to take a defense of the policy in the trial court, it is the duty of the insurance policy, insurance company exhibit the said policy to take the defense. In this case, they are trying to take the defense of the premium, and if they are trying to take the defense of the premium, it is the duty of the insurance company to exhibit the policy. The relevant portion is at paragraph number 10, which is highlighted by marking with red ink. I'd like to read para 10. I have marked it in red ink. We accordingly wish to emphasize that in all such cases where the insurance company concerned wishes to take a defense in a claim petition that its liability is not in excess of the statutory liability, it should file a copy of the insurance policy along with its defense. This is the mandatory requirement which has been observed by the Honorable Supreme Court. And in this case, there is no policy exhibited by the insurance company to take defense of that fact by saying that there is no coverage. So in the absence of such defense taken by the insurance company, it cannot be taken, a plea cannot be taken at this stage by the insurance company. And therefore, I am humbly submitting that this appeal may be dismissed and passed in favor of the other respondents. That much. All other submission which has been raised by my learned friend for the respondent number 1, I would like to adopt to those submissions.
Who's representing the company? Not the insurance, the IOC, what do you call it?
Zofed. I am.
Zofed. Okay, Zofed.
The respondent number 2. Respondent number 2 is unrepresented in this case.
Okay.
Sorry, 3.
You are this Zofed.
Yes.
So you're okay. I got it. This
not-
point was not, premium was not raised, therefore
yes.
they had no time
Yes.
when they were examined.
Yes.
Were you you had represented the Zofed in the trial court
Yes.
also?
Yes. Yes.
Oh, okay.
Written statement was submitted. That much.
Okay.
And
Yes.
in fact, that also has been said. The insurance company has not led any evidence in the trial court also.
Yes, that's it.
Yes, two rebuttal. Number one is regarding that issue
yes.
of not raising that.
Yes.
If we remain at page 59, my
59,
written statement, at para 2 and 3, sorry, 4. Out here I've stated there is no cause of action in favor of the claimant and against the opposite party number 2, so and so. Fourth, Your Lordship. It is humbly submitted the liability of the company opposite now party number 2 insurance company is subject to the terms and conditions of the insurance policy. Subject to the terms and conditions of the insurance policy and as per the relevant laws. Number 1. So I have stated this. Number 1 is that. Number 2 is that my learned friend has stated that no issues were framed on this point of premium being paid or not being paid or who would be liable to pay. In that respect, Your Lordship, if we look at page 27, relevant page is at page 28, issue number 3. It is very clear. It says whether the claimant is entitled to compensation. Obviously, the entitlement of compensation of the claimant will be decided depending on the policy.
Okay, fine. Whatever. Now, did you give your evidence before the court?
No, I did not. That is there. And so, the issue raised by my learned friend that this issue was no issues were framed on this, so the point could not have been decided by the trial court is factually incorrect. Whether the claim is entitled to compensation will depend on the nature of the policy, obviously. And if so, to what extent, who is liable to pay? Again, it boils down to the insurance policy. And my learned friend appears to be under the wrong impression, I'm like, with all due respect.
Okay,
is that
so let's see your cross. Did you cross the during the cross examination? Was this point ever raised?
No, we did
Did
not
you
raise
ask-
this. We did not raise.
During
Admittedly,
cross- but you were there. You were there. You were.
we
you
were there
present,
for cross examination.
But you did not raise this
on
issue.
this particular issue. We did not. Anyways, Your Lordship,
Yes.
that is number 1. Number 2 is that the burden of proof is on them. Now, my learned friend had produced one judgment. That is a situation where the insurance policy was not produced by the claimant. In this case, it was the claimant who annexed the insurance policy. As such, it was on them. The burden of proof was on them.
So who
say
exhibited
that-
the insurance
claimant.
policy?
The
The
claimant.
claimant exhibited the insurance company.
Yes.
And then you were crossed. The claimant was crossed.
Correct.
At the time of cross-examination, any specific question asked about the
Premium.
premium?
No, I will admit that there is no particular cross-examination on this particular point that I will admit. In any event, Your Lordship, since it was them who produced it and it was them who approached the tribunal, it is the burden of proof is on them to show that yes, we are entitled as per the policy A, B, C, D. It was on them. That was their burden. That was their burden to discharge. Now, secondly, as far as the income is concerned, they're saying that one income certificate has been issued by the respondent number 3. And if we come to page 29 at the bottom of the exhibits, it says Exhibit C3. At Exhibit C3, proof of income certificate issued by Lalnithanga. Exhibit
Yes.
C3. So this is a proof of income certificate issued by Lalnithanga,
Lalnithanga is the.
respondent number 3.
Oh.
Unfortunately, Your Lordship, the signature of Lalnithanga was not exhibited by Lalnithanga during his cross-examination. So how do we know that it is the one and the same document?
Okay, let's see the exhibit.
There is no exhibit. Para 10, page 34.
Page 34.
It starts from at para 10 at the bottom. And if we keep going, there is no exhibit. It ends at page 36.
No, so let's look at the documents, exhibit in the court.
So how can the claimant exhibit a document which he did not issue?
Wait, see in the court,
C3.
before the trial court, let's see C3, was it exhibited?
It was exhibited as display as I had just highlighted.
By the claimant.
By the claimant. That's what I'm trying to impress. So a document issued by the respondent number 3 has been exhibited by the claimant. So the
But
claimant was duty bound.
Was it this thing? Let's see. How was it claimant had exhibited?
Claimant exhibited.
Now he's saying that this is the. Okay, so his signature. He has not identified his signature, maybe.
yes.
Correct.
That's your point.
Exactly. My point is that the person who issued the document, the author of the document, was
Okay,
called
he has
on.
not,
He has not
identified his signature.
got to confirm that it was in fact a document issued by him.
Okay.
So the burden of proof is on the claimant, who says that this is a document issued by the respondent number 3. When the respondent number 3 was called upon, that burden was not discharged.
Okay, fine.
With that, I conclude my submission.
Lordship, may I, in that point, Lordship, that signature was identified by the person who issued the income certificate, which is at Exhibit C7A, which has been clearly.
Where is C7A? Where
His
are
signature.
the exhibits? C7A.
C7A,
Page?
Lordship. Lordship, it's in that appeal memo. It's page 34.
It's all in the appeal memo.
Yes, Lordship.
Page?
Page 34. Page 34. First paragraph, last line. Last line. He identified Exhibit C7A, his signature.
What is C7? C7 is the
No,
birth,
C7
the
is
income
the-
certificate?
Police report.
Sorry, Lordship. Is yet exhibited?
Income certificate is something else. They're not C7. You were
Yes,
saying something else.
I concede on this point. My learned friend is correct.
Yes.
I concede.
C7.
C3A is.
C3A, sorry, not
C3A.
I concede. I
Okay,
missed it.
identified.
Yes.
Identified. In any event, Your Lordship, it was not proved.
It's all right, it's all right.
Okay. Heard Mr. Lal Fakoma. Learned counsel for the appellant. Also heard Mr. Johnny L. Torchong, learned counsel for respondent number
1, Your Lordship.
1/claimant. Okay, and Mr. Roshan Subedi, learned counsel for respondent number 2. Hearing concluded, matter reserved for judgment.
Even though